It is interesting when you've experienced many of these hearings, the nature of the questions that are asked. Some of the questions challenge the individuals on the panel because they ask them for personal views on issues, and many are instructed by the canons not to share personal views, but to try to stick with the law and not to prejudice any pending case or any future case. And so it puts many of the nominees in a tough position. We all have opinions on things, but judges do their best to suppress those and follow the law and facts in the case, which they're asked to do. So it creates a challenge in that regard.
Mr. Chairman, may I be heard on that?
When I finish, please.
Sure.
And I also want to say that many people have jobs to do that are created by statute and by law. For instance, to represent certain clients, Solicitor General would be representing, in some cases, the views of a mayor that are expressed through policy and through ordinances and laws and the like. They may not be views that you personally share, but as a litigant, you have a responsibility to be loyal to your client, not to allow them to lie or have anything they say that is misleading be part of the record, but to honor them and defend their position. One member of this panel said, and I think properly, as a litigator, you do not necessarily share the views of the people you represent. In fact, very often, having been a litigator myself, I would say that you may disagree quite strongly with the views of the people or the litigating positions, even of the people you represent, but it's your job to represent them effectively and fairly. That was the senator from Missouri, and I think he was right in the citation that I've just read to you. I could go through the panel and say that depending on the nominee, each of us has said something like that. You do your best for your client, even though you may not agree with their fundamental policy views. You have a responsibility to represent them effectively and professionally. Senator Kennedy.
Thank you, Mr. Chairman. I agree. I concur in part and dissent in part with our esteemed chairman. I think he's right. We're all attorneys. We've all had clients we didn't agree with. Hell, we've had clients we didn't like much. But you do your job as long as it's ethical. And I can't recall a time that I have really pressed a nominee on a position that nominee took on behalf of a client, if I thought it was in good faith. I disagree with our chairman that your personal beliefs don't matter. Those of you who I questioned today, I specifically asked you if you'd allow your personal beliefs to influence your decisions, and you said no, and that's as it should be. But if you don't have personal beliefs, and you're not qualified to serve on the federal bench, you're just not. If you don't have personal beliefs, you're not a critical thinker. If you don't have personal beliefs, you haven't examined the world. You've just been robotic, doing what somebody told you. I think your personal beliefs do matter. And I think you ought to be able to discuss with us things like race in society, things like when does life begin? These are things that we all grapple with as Americans, as human beings. We need to talk about when does equal protection of the law attach to a person? Does it attach in the womb? Should it attach in the womb? We need to talk about racial progress in America, what we've gotten right, what we've gotten wrong. America caught the disease of slavery, but we beat it back. We should be able to talk about that. I've never asked your opinions or a nominee's opinions about a case that was pending before them or that might be pending before them. But when you come before this body, at least this is one person's opinion, when you come before this body and you refuse to answer a question about your personal beliefs, people are going to assume what they want. And sometimes they're going to assume correctly, and sometimes they're going to assume incorrectly. But they're going to assume, and they're going to attribute that belief as your belief. So I think you're making a huge mistake. I understand I've served only with 2 presidents. White House counsel's offices do their job. They get you prepared. They give you the questions that have been asked in the past. I get all that, okay? But I just have to dissent from my chairman that your personal beliefs don't matter, because they do. They do a lot. And they tell us a lot about you. Thank you, Mr. Chairman.
Senator Kennedy, I respect you much, and I count you as a friend. But you and I both know the experiences we've been through in this committee. Nominees, potential nominees, even for the highest court in the land, would not take a somewhat neutral position saying, as a judge, my personal views don't count. They instead give us obfuscation. We've seen it happen on both sides of the table. You would think an issue as fundamental and basic and as well known as the issue of abortion would be one that you could express yourself on, where you stand, what you feel. But many, including nominees for the Supreme Court, would tell us, oh, you're talking about established law and established precedent. Then along comes the Dobbs decision, and you say, what is this all about? You know, this isn't what you promised was going to happen. It didn't come out that way. So I understand nominees are in a difficult position. They're trying to follow the canons as they understand them as nominees and as sitting judges. And they don't want to prejudice future cases or pending cases that they might sit on. So that's just part of this process that both sides will use to their advantage when possible. And I respect you. I think you're a person of value and principle, but we disagree on this.
Well, Mr. Chairman, if I could just respond, though, to that. And Dick, I appreciate that point of view. I think Supreme Court nominees are in somewhat of a different position because they're going to be making the ultimate law of the land. I think lower court nominees are not in the same position. And I just don't see what we gain by not being able to talk about what people believe. I mean, I would like to hear what thinking people believe about, for example, is sex a biological fact or a social construct? I mean, I assume all of you have thought about that and have an opinion. I would also point out, Mr. Chairman, this isn't a criticism, you're following past precedent. But each one of these individuals, if they're confirmed, are unelected. They're there for life. For life. And we're not allowed to talk about what they believe. And we're only given, again, this isn't a criticism, 5 minutes?
Well,
come on.
By that logic, if you apply it to the highest court in the land, how many of them have been in elective office?
Some haven't.
Most haven't.
But that's why we also have, well, Earl Warren was, but that's why we also...
You have to go back in history.
That's why we also devote days to a Supreme Court hearing.
Yes, instead of 5 minutes, we take 15.
As we should.
Yes.
With second and third rounds.
Well.
But anyway, Mr. Lee, my good friend, wants to say something.
I have to be at a place right now, so please.
I will be brief. I just wanted to respond to the point about Dobbs. I've heard some colleagues say this, sometimes in the context of this committee's work, sometimes in other contexts, that there's this suggestion made that because nominees came forward and acknowledged that Roe versus Wade was established precedent, that somehow locked them in, and that they had, under oath, somehow betrayed their obligation to testify truthfully under oath. For every hearing that I've been a part of, and I've been here for 4 Supreme Court confirmation proceedings, not one of those justices who's been complained about, in the wake of the Dobbs decision, said that Roe or any other case was unassailable on any grounds ever. or was somehow protected under the doctrine of stare decisis from the possibility that future courts could conclude, as the court did conclude in Dobbs, that Roe versus Wade was without textual foundation in the Constitution, that it was without the kind of foundation that could make it a part of the constitutional analysis, not rooted in our nation's history, tradition, and so forth, as a matter of due process. Now, I take issue with the suggestion that any one of these nominees misrepresented in any way, shape, or form their views on the Dobbs case. They could not answer further questions about whether it was assailable under a challenge, and they made no representations as to how it might fare under the doctrine of stare decisis. Such questions, when asked, are questions that they're understandably not allowed to answer under the canons of judicial ethics. Thank you.
So as chairman, you take the last word. The people who were appointed to the Supreme Court by the Trump administration were pre-cleared for one purpose: to overrule Roe versus Wade. The Federalist Society, which was the secret handshake for every nominee who came before us from the Trump administration, was established for that purpose. We know that. Regardless of the questions answered here in the Judiciary Committee, we knew what they were aiming for, and they finally reached that goal with the enactment of the Dobbs decision. But if you listen to their testimony before this committee, they carefully misled us or obfuscated the situation. You may disagree with me, but that's my opinion. I look at it and I thought to myself, I know where this nominee stands, and I'm not going to name names, based on their life experience and where I've seen them rule or speak in the past. That's just the nature of this process. As I said, I get the last word because I'm chairman, so thank you. We'll carry on this discussion, I'm sure, beyond today. Thanks again to the nominees, their family, and friends.
Well, Mr. Chairman, with a bold statement like that, I think you ought to let Mike respond. I don't think that's fair.
It's just not accurate. In
That's a pretty
no
bold
respect,
statement.
you have defamed them. You have accused them of committing a crime here. That is a crime to testify falsely under oath. They did not do that. I challenge you to find one statement that you could defend as knowingly false made by them, as perjurious. That's what you've done. That's not appropriate.
I said we selectively misled. I didn't say whatever you just said, feloniously.
From an ethical standpoint, that has the same effect, and they did not do that.
Without describing one another as defamatory. This meeting stands adjourned.